Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers trash can searches, resisting an officer, and securing a residence, and is brought to us by Code Blue Cam. Be sure to check out the description below and give them the credit that they deserve. On November 8th, 2022, officers from the Wausau Police Department responded to a report of a stolen backpack in Wausau, Wisconsin, after the backpack's owner used an Apple AirTag inside the backpack to track its location to the residence of 19-year-old Mario Camacho. Officer Austin met the owner on the sidewalk outside of Mr. Camacho's home and began to question him about his missing backpack.
Good. Matthew?
Yes, sir.
Officer Austin, what's going on?
So, my bag got stolen today.
Okay.
I wouldn't really care for it, except there's military documents in there that I need. They got pinged at this house right here. I knocked on both the doors and they said they don't want anything of it. It was at this house right here. I mean, it's kind of bugged around, but her and I drove here and it's been, I don't know. I mean, I looked in the grass, maybe somebody threw out the window, but I can't find anything.
Can you just show me the ping again, just kind of where it's...
Usually it's right there, but before it was right over here, so it's kind of been jumping back and forth. I don't know if somebody's moving it around. It's like a black military combat bag. But there's a blue binder in there. Yeah. It has my banking information, my notes, my military documents. I need that binder.
Could very well just be in the garbage. Sounds like somebody answered the door though.
Mario? Okay. So you got the backpack here, or?
I actually don't. I have neighbors, and he told me that he talked to them.
Okay. These neighbors over here?
Or these ones. I don't know. He came to this house.
Oh yeah, the AirTag is going right here.
What?
Okay.
At this address, it can be. The only one here I know what is in this house, and there's definitely no backpack in here.
All right. Just I might come back to chat with you. Just hang tight.
5962. Can you advise, were any purses or brown wallets taken from these vehicles? These garbage cans are full of purses and brown wallets.
Are you guys allowed to look through my property?
Hey, garbage? Yeah.
What's going on? What's going on? I just want to know what's going on because I drove by and I seen y'all searching through my brother's trash can, so I'm just wondering what's going on. Well, someone's got to let me know what's going on. Can you tell me what's going on?
Do you live here?
I come here often and I drove by and see you guys searching my brother's garbage can, so I am just wondering what's going on.
Okay,
And
well,
there's cars out
if
here.
you don't live here, you don't need to know right now.
Actually, I do. Mario, what's going on? Who are these people?
They're the ones who called us.
I'm just trying to figure out what's going on.
So,
why I just
he
drove
had
past
a
you guys
bag
and searched through
stolen.
my brother's
Will you let
garbage
me talk?
can.
Will you let me talk?
I actually been asking y'all to talk since
Okay.
I pulled up here, so
Well-
yeah, go ahead. Thank you.
So, he had a bag stolen from his car last night. Had an AirTag in it. AirTag places it somewhere between these two houses. We're going to go next door, but the AirTag shows
Okay,
it right
that's
here.
fine, but don't go searching through my brother's garbage can for
It's public
y'all don't have the
property.
right to do that.
That's
And y'all
public
know
property.
better than that because y'all are police officers.
We have the authority
It's really
to
that.
search the garbage.
No, you don't. Now without my brother's permission, you don't. That's illegal in a... I can't even search my neighbor's garbage can. Don't do nothing like that without his permission. Thank you.
After the officers searched through Mr. Camacho's garbage cans, Mr. Camacho's sister, Shertisha Camacho, who happened to be driving by, pulls into the driveway and tells officers they cannot search Mr. Camacho's trash without a warrant. The Supreme Court decided in the 1988 case of California versus Greenwood that the Fourth Amendment does not prohibit the warrantless search and seizure of garbage bags left on the curb for collection because, now quoting, it is common knowledge that plastic garbage bags left on or at the side of a public street are readily accessible to animals, children, scavengers, snoops, and other members of the public, and the defendants, now quoting again, place their refuse at the curb for the express purpose of conveying it to the trash collector, who might have sorted through the trash or permitted others, such as the police, to do so. The court concluded that the defendants, quote, could have had no reasonable expectation of privacy in the inculpatory items that they discarded. However, unlike the trash bags in the Greenwood case, which were placed on the curb for trash collection, Mr. Camacho's trash cans were against the side of his house in what is known as the curtilage of his home. The term curtilage is broadly defined as the area around a house that residents use as part of their daily lives, such as driveways close to the home, porches, walkways, and yards, where the occupant has a reasonable expectation of privacy. And courts have long held that the Fourth Amendment Amendment protections against unreasonable search and seizure that are given to an individual's home also extend to the curtilage. In the 1991 case of U.S. versus Hedrick, the Seventh Circuit Court of Appeals, which has jurisdiction over Wisconsin, concluded that where the garbage is, quote, readily accessible from the street or other public thoroughfares, an expectation of privacy may be objectively unreasonable because of the common practice of scavengers, snoops, and other members of the public in sorting through garbage. However, the court also noted that, quote, on the other hand, garbage cans placed next to the house or the garage are not so accessible to the public that any privacy expectations are objectively unreasonable. The trash cans by Mr. Mario's home were positioned against the wall of his home, a few feet away from his front door, and separate from the lot beside it. Given the trash cans' immediacy to the home, it is likely a court would find that Mr. Camacho had a reasonable expectation of privacy, and therefore that the officers could not search them without a warrant. On the other hand, due to the short length of the driveway, the visibility of the trash cans from the street, and the accessibility of the trash cans to the general public, it is also conceivable that a court would conclude that Mr. Camacho did not have a reasonable expectation of privacy in the contents of his garbage.
Okay. So what are we doing right now?
Here. Alright, who else is home right now, Mario? Just you? Alright, I'm gonna have you step out.
Are you?
Have a seat for me. I'm gonna be securing the residence because the residence smells like weed and we're gonna be applying for a search warrant.
Hey, Tisha. Hey, they said they smell you.
Y'all don't smell no weed, so y'all can
Stay
get
out here.
Stay out.
Stay
I don't
out.
smell weed. My brother
Stay
don't
out.
smoke weed. So
Stay
did
out.
y'all check the neighbor's house if y'all smell weed?
Stay out.
My brother don't smoke weed, so it don't smell like weed in here.
Stay out.
Get out of my brother's house before I call a motherfucking lawyer. Or don't grab
Put your
me.
hands behind your back.
Okay, that's fine. They don't have the right to do this. Smell Mario's house. It don't smell like weed in there. No,
Stay out of the house.
Justin, just go get
Go
right
back in the car.
Justin,
Get
go
back
get
in
in
the
the car.
car.
I'm gonna get
Now.
right back out.
Have a
They
seat.
don't. Y'all don't have the right to search this
Have a
house.
seat.
I will. Y'all don't gotta grab me up like that. Be mad.
You
Just
do
tell
not
them.
have the right to go in my house.
We're
Without a
securing the
search
house.
warrant. Tell them that, Mario.
Application of a
Tell them
search
that.
warrant. We are not searching the house.
Well, you guys were just in there without his permission after we told you not to be in there. Stop breaking my laws, and this would be a lot simpler. If y'all leave, this would be solved. Way simpler without y'all here.
Go look at my
Mario, they don't have the right.
Can you put her in your
Mario,
Yep.
Mario, because you see they try to take me to jail because they Mario, they can't get into your house. The only reason they're in there is because you told them to go in the bathroom.
Stop.
No, I'm just
Stop. That's in the bathroom.
So what's in the bathroom?
I'm just yelling, dude. I'm just yelling.
Now is the time where you're under arrest. You're going to get searched.
That's fine, but under arrest for
Stop
what?
moving.
Sir, 1, 2, 3. What am I under arrest
Stop
for?
moving.
Are you gonna tell
Right
me?
now is resisting. That's what you're under
I'm
arrest
not
for.
because I'm not moving. I'm just talking. But what am I being arrested for?
Told
What
you
am
right
I
now is
being?
resisting.
Why am I in a handcuff?
Because you're not listening.
Because I'm yelling. I don't have to listen to y'all.
Yes,
I'm a
you
grown woman. I can yell if I want to.
After Ms. Camacho opposes the officer's entry into Mr. Camacho's residence, the officers inform her that she is under arrest for resisting. Wisconsin's resisting and obstructing statute, which is found in section 946.41 of the Wisconsin statutes, states that, quote, whoever knowingly resists or obstructs an officer while such officer is doing any act in an official capacity and with lawful authority is guilty of a Class A misdemeanor. The Wisconsin jury instructions for this statute define resisting an officer as opposing the officer by, quote, force or threat of force, and states that, now quoting again, to obstruct an officer means that the conduct of the defendant prevents or makes more difficult the performance of the officer's duties. Now, while it is evident that Ms. Camacho's actions made it more difficult for the officers to search Mr. Camacho's residence, Ms. Camacho would have a legitimate argument that her arrest was based on speech that was protected by the First Amendment. In the 1987 case of Houston versus Hill, the Supreme Court overturned a conviction for, quote, willfully or intentionally interrupting a city policeman by verbal challenge during an investigation against an individual who shouted, and I'm quoting, why don't you pick on somebody your own size, at police officers who were investigating his friend. In reaching this conclusion, the court recognized that, quote, the First Amendment protects a significant amount of verbal criticism and challenge directed at police officers, and that the Constitution requires that, quote, in the face of verbal challenges to police action, officers and municipalities must respond with restraint. However, as the 4th District Court of Appeals of Wisconsin stated in the 2021 case of State versus Olliston, quote, "While speech alone is generally not susceptible to criminal prosecution, speech can be criminally punished when it goes, now quoting again, beyond mere expression of ideas, and such conduct may be penalized when it causes, quote, substantial disorder or the invasion of the rights of others. For this reason, the court upheld disorderly conduct convictions against an individual when his speech was paired with, quote, non-passive, physically confrontational conduct of approaching and targeting specific officers at close range while shouting in a loud, forceful manner. Based on this precedent, it is possible that a court could conclude Ms. Camacho's behavior went beyond speech and could therefore be punished without implicating the First Amendment, particularly if the court interpreted any of her movements to be an attempt to enter the residence. Additionally, it should be noted that in order for the resisting and obstructing statute to apply, the officers involved must be acting, quote, with lawful authority, which, as the Wisconsin Court of Appeals recognized in the 2008 case of State versus Ferguson, requires that police conduct complies with both the federal and state constitution, in addition to any applicable statutes. We will discuss the legality of the officer's entry into Mr. Camacho's residence later in this episode, but for now, it is important to keep in mind that Ms. Camacho could not be convicted of obstruction if the officers were engaged in unconstitutional conduct.
Y'all weren't listening when my brother said not to go in this house for a... I don't even know.
We're writing a search warrant. We have a right to freeze the scene. We're not searching.
That's fine.
Okay, Mario, let me explain to you what's going on. Showed up here, okay? The air tag was popping in, all right? Open the door, smells like weed, okay? That gives me the right, by law, to secure the residence for the application of a search warrant, which I will be doing. That means I can go inside, secure you and any persons that would be in there. In that cursory protective sweep, we located our backpack that you said wasn't there, okay? Obviously, that's an issue we will address. Part of how we can approach this type of issue now is I can absolutely continue to proceed and apply for that search warrant. The alternative to that is, with your consent, I can also search this residence. Obviously, we know we're going to find a backpack.
Officer Austin informs Mr. Camacho that the fact that the air tag pinged to his location, combined with the smell of marijuana coming from the house, gives the officers the authority to quote-unquote secure the residence while they apply for a search warrant. Under the Fourth Amendment, a search warrant cannot be issued without probable cause. And although the Supreme Court held in the 2012 case of United States versus Jones that officers must obtain a warrant before attaching a GPS tracking device to a suspect's vehicle, and presumably other items, courts have upheld probable cause findings based on GPS data supplied to the police by third parties. For instance, in the 2015 case of U.S. versus Mitchell, the U.S. District Court in the Eastern District of Wisconsin determined that officers had probable cause to arrest an individual for robbery when dispatchers received tracking information from GPS transponders placed in so-called bait money during a robbery, noting the, now quoting, accuracy and reliability of GPS technology. Likewise, Wisconsin courts have generally found that the smell of marijuana from a home gives officers sufficient probable cause to obtain a warrant, given the fact that both the medical and recreational use of marijuana is illegal in the state. Given this precedent, it is likely that a court would find that the officers had probable cause to obtain a search warrant for Mr. Camacho's residence, despite the fact that the GPS ping had occasionally moved, based on the combined evidence of the GPS ping and the smell of marijuana, although Ms. Camacho disputes the existence of any odor. Accordingly, because the officers likely had probable cause to obtain a warrant and were reasonably concerned about the destruction of evidence, a court would probably conclude that they could briefly enter the home and hold Mr. Camacho outside to quote-unquote secure the residence while awaiting a warrant. In the 1984 case of Segura versus United States, the Supreme Court held that, quote, securing a dwelling on the basis of probable cause to prevent the destruction or removal of evidence while a search warrant is being sought is not itself an unreasonable seizure of either the dwelling or its contents, and upheld a warrantless entry into a dwelling that included, quote, a limited security check of the apartment to ensure that no one else was there who might pose a threat to their safety or destroy evidence, and 2 agents remaining in the home for approximately 19 hours hours while a warrant was obtained. Likewise, in the 2001 case of Illinois versus MacArthur, the Supreme Court determined that officers did not violate the Fourth Amendment by preventing an individual from entering his residence for 2 hours while waiting for a warrant when they had probable cause to believe that the residence contained unlawful drugs and had good reason to fear that if the individual was allowed to enter his home, he would destroy the drugs before they could return with a warrant. Based on this precedent, it is likely that a court would conclude that the officers did not violate the Fourth Amendment by conducting a brief protective sweep of Mr. Camacho's home to ensure that there was no one inside who could destroy evidence, or by ordering Mr. Camacho to stay outside of his residence while they obtained a warrant. However, it is important to note that the case law clearly indicates that in this type of situation, officers generally cannot conduct a full search of the residence until the warrant is actually obtained, and that the legal analysis for this situation could be different if the reviewing court did not believe the officers' claims that they smelled marijuana.
Mainly what we're here for, and probably could have avoided it if you would have just turned that over to begin with. But now we've gone obviously a little bit too far. Is that your sister there? That got a little bit too vocal about things, even though we were 100% within our right. With that being said, I'm going to ask you, will you give us consent to search your building here?
I don't care if you guys search it, just please do not mess.
We're not going to help with it. Is there any weed in there that we need to be concerned
But
about?
I have bags of clothes. I need to do laundry.
Okay. I'm not concerned about laundry or anything like that, but you give us consent to search your residence here.
Actually, I don't, because a responsible person, I would rather wait until we get word from the judge. You know what
That's
I mean?
fine. That's fine. At this point, I'm going to place you under arrest for theft at this point.
There's nothing else that can happen after this.
Right now.
After the arrest, Mr. Camacho was charged with felony and misdemeanor receiving stolen property and misdemeanor possessing drug paraphernalia. As of the date of writing this episode, these charges are still pending. Ms. Camacho was initially charged with a felony offense of threatening a law enforcement officer and resisting, but as a result of a plea agreement, the felony offense was dismissed, and the resisting charge was amended to a charge of disorderly conduct under Section 9.21 of the Marathon County Code of Ordinances, which is not a criminal offense. Ms. Camacho pled no contest to this violation and received a $50 fine. It is unclear whether the Camachos have filed any complaints about the interaction or if they intend to take any legal action against the officers involved. Overall, the Wausau officers get a C, because although they managed to defuse the situation without physical violence and ultimately returned the caller's stolen backpack, their decision to arrest Ms. Camacho and their search of the garbage on the curtilage of the home were both questionable at best. Building probable cause is often a tedious element of the investigative process, especially in cases where it is clear that criminal activity has occurred, but more evidence is needed to warrant police action. It is important for officers to gather this evidence in a manner that respects the rights of the individuals involved in the investigation, regardless of the situation. While the Wausau officers' search of the garbage can outside of the home did render useful evidence, the nature of the search was questionable, and the case law surrounding it leaves room for an astute defense attorney to potentially have the evidence dismissed entirely. The legality of the arrest of Miss Camacho is also highly questionable. Once the Wausau officer stopped her from attempting to enter the home and informed her that she cannot enter while they secure the residence, she did not continue attempting to gain access to the home. Instead, she stood at the doorway and verbally expressed her disdain for the conduct of the officers. At no point did Ms. Camacho physically interfere with the officers, and there is an argument to be made that her conduct was protected by the First Amendment. This interaction highlights the importance of officers conducting a thorough and lawful investigation and possessing a deep understanding of the protections offered to citizens by the First Amendment. Ms. Camacho also gets a C, because although I commend her for attempting to stand against what she believed to be an illegal search, she maintained a hostile and confrontational attitude throughout the encounter, and failed to invoke her right to remain silent at any point, even after being arrested. As mentioned before, it appears as though Ms. Camacho's conduct falls under First Amendment protection, and merely expressing contempt for an officer's actions is typically not an arrestable offense. All that said, Ms. Camacho's conduct only served to escalate the situation, and her refusal to remain silent could have negatively impacted her legal defense or any potential civil suits. Later in the video, as Ms. Camacho was being transported to jail, she made several vulgar remarks to the arresting officer, which could be seen as unfavorable by a judge or jury.
Piece of shit, I hope hope your motherfucking wife gets.
It is clear that Miss Camacho let her emotions get the best of her during this encounter, and this interaction highlights the importance of remaining calm and collected whenever interacting with members of law enforcement. As for Mr. Camacho, it is difficult to assign him a grade given the information at hand. Although he was arrested for receiving stolen property, those charges are still pending, and he may have a legitimate legal defense against them. Mr. Camacho may not have known that the backpack was inside the residence, and it would be reasonable for him to refuse a search of his home even if he was innocent, regardless of the situation. Based solely on the video footage, it is impossible to determine whether Mr. Camacho actually violated the law in any capacity, and any conclusions regarding his guilt or innocence should be left to a court to decide. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.